There we go.
All right, so we'll go ahead and do a roll call vote. Bryant?
Yes.
Bruce?
Yes.
Walter?
Present.
Chris?
Yes.
Cheryl? Here. So we're going to now do a vote to enter executive session. The vote to enter executive session is in accordance with Massachusetts General Law, Chapter 30A, Section 21A1, to discuss the reputation, character, physical condition, or mental health rather than professional competence of an individual, or to discuss the discipline or dismissal of or complaints or charges brought against a public officer, employee, staff member, or individual. So I'm going to declare that we vote to enter an executive session. I'll make that motion.
And you should also vote to exit.
The last part of your motion might say that.
And the chair so declares to reconvene an open session. Okay.
You just need a second.
Second.
All right. All in favor, roll call vote. Bryant?
Yes.
Bruce?
Yes.
Chris?
Yes.
Walter?
No, because as I'm an individual identified in this complaint, I'm requesting to this board in the provision of Chapter 30A, Section 21A1, this meeting will be held in open session.
Okay.
So the motion was to go into executive session. You technically the motion, go ahead, Kate, you're the one.
The motion passed, but as the individual named in the complaint, the target of the complaint may be able to demand that it be held in open session. So that is his right, and he has made that declaration. So we will have the meeting in open session.
That said, an open session meeting now changes that we now have to adjourn and schedule an open session meeting. So I've been
No, that is actually not true.
okay. Well, this Kate, good. I hope this doesn't. You end up in the bar association on this. Okay.
Okay, I will take that on. The DOG has determined that if it's posted as an executive session meeting, you can always have that same topic discussed in open session. And the public is sufficiently on notice because either the board may determine not to go into open executive session by vote of the board, and or the target of the complaint may elect to have it in open session as you have done so. If you wish to change your mind, you can let the board know.
Would you prefer to have it in executive session?
God, no.
Okay. All right. Well, I had sent out the complaint and the video to the board in advance.
And for the record, when was this sent out?
It was sent out on the day of the letter. So Wednesday.
Did anybody else have seen this complaint prior to that date?
The board had only seen it on the day of the letter.
Thank you.
Does anyone have any questions or comments about the complaint or the video that they saw, or do they have any questions for Walter? Anything that you would like to say, Walter?
Well, actually, before that, I have a question. Actually, it's more for our attorney. I've read, first of all, I'm on the planning board. I'm also, I guess, the only attorney in the room. I read the,
Bruce, you still licensed as an attorney?
well, I'm retired. Well, whatever. Anyway, I was just mentioning that as background. I read the Mass General Laws, Chapter 38, Section 21. And my question is this: if there is nothing in the town charter that talks about disciplining members of elected boards, and there's nothing in the planning board rules and regulations that speaks of disciplining members of elected officials, well, I said planning board members. And there's nothing in the town bylaws that speaks of disciplining elected town officials. Is the Mass General Law, is that setting out parameters for a hearing that otherwise, that exists under town rules? Or is it creating the rights to the hearing? I mean, I honestly don't know the answer. That's why I'm asking. If you
So
don't understand my question, I'll try to make it clearer.
and you're asking me, sir, is that right?
Oh, you're the
Yeah.
attorney for the board.
I couldn't hear the beginning part, so I wanted to make sure you were asking me.
Yes.
Let me see if I can restate your question so I'm clear I'm answering your question. So your question is whether or not, in the absence of a provision in a charter or a bylaw, discipline
Or rules and regulations.
may be and rules or regulations, discipline may be imposed on a planning board member and that's question number one. And then question number two is whether a discipline hearing can occur in the absence of a provision of a bylaw.
Well, my question was, if there's nothing in this case, the town, but rules, regulations, bylaws, charters,
Mhm.
which sets forth a disciplinary procedure or process or whatever. Is the purpose of the Mass General Laws section cited in the letter does it create the disciplinary procedure, or is it there to set forth ways of holding a disciplinary procedure that's otherwise already authorized by the town or city? If you followed what I'm saying. For example, in the Mass General Laws, it says that the person has the right to have an attorney with them. Although apparently the attorney isn't allowed to speak to the meeting, but I mean, is it just setting forth the method that the hearing, the otherwise existing hearing should be run, or is it creating the basis for the hearing?
So what that provision of the open meeting law provides is simply the mechanism to enter into executive session. And then if that election is made, then certain additional rights are granted to the public official. So it's merely if you go into executive session, these additional rules apply. So if you had a provision in your charter, and many charters do, say it was someone completely different, town manager who was being different, there may be separate removal provisions which require greater notice, participation of the lawyer, all those kinds of things. They're over and above what is required by the open meeting law. So the open meeting law is simply setting forth the parameters for a board to engage in a discussion regarding a complaint against a public official, if done in executive session. Other than that, it has no bearing. So since this is being discussed in open session, those open meeting law rights don't necessarily attach. We were noticing them in the event that we were going into executive session. And the whole idea being that someone's not taken by surprise in executive session. Now, gosh, I'm so sorry. Yes. It has been notified of the complaint, and so and specifically given all the evidence that has been provided to the board. And so therefore his due process rights have been fulfilled. He has the opportunity to respond to those complaints, etc. So again, those satisfy his due process rights. In terms of discipline, an elected official can't be disciplined, right? You can't remove, like you would another employee, remove a person from an elected position. The only way to remove an elected officer is through a recall procedure or not.
Hold on, we do not have that provision, and I was reminded of that. We do not have a provision
or not re-electing them. But there is no discipline protocol. It doesn't necessarily mean that a board can't say this is not how we operate, and we would request and expect our members to act in a certain way. So you can advise the public that this is not a position that the board takes, and you would expect your members to behave in a certain way. But there is no way to quote discipline an elected official. If that answers your question, I hope it did, and maybe a little bit more. Was there anything more that I didn't answer?
Okay, so basically investigating allegations against a board member is, I don't know, an inherent right of the planning board in this case, and it doesn't need to be specifically whatever enumerated in town bylaws, charter, rules and regulations.
You're responsible as elected officials to respond to complaints by members of the public, and manage that in the best way you feel appropriate.
Okay, this is the first time anything like this has ever happened.
No, of course, yeah.
Okay, thank you.
It's my suggestion tonight. I have a prepared public apology that I think would be warranted to issue tonight if the board agrees based on the interaction that you had, Walter, in January. I'm happy to read it and we can
Yep,
vote on
sure.
that unless anyone wanted to discuss it.
Well,
What happened?
read it first and we can discuss. Okay.
So the Town of Long Meadow Planning Board would like to take this opportunity to issue a formal public apology to the Ochoa family for the actions of one of our members on January 7th, 2025. On that date, Planning Board member Walter Gunn, unbeknownst to other members of the Planning Board, conducted an unannounced site visit to their residence. This interaction with Mr. Gunn was documented and reviewed by members of the Planning Board. Every citizen deserves to be treated with respect and dignity by our town officials. An official acting outside the scope of authority and who makes derogatory comments erodes the trust of citizenship and the ability of the town to uphold the rights and respect of all citizens. Upholds. The Long Meadow Planning Board denounces the actions of Mr. Gunn and vehemently states that his actions and statements do not reflect the sentiment of the members of the board.
Oh, okay.
So motion.
It
No,
wasn't a
no,
motion.
we're just-
I read it
we're
for
just
discussion.
reading it.
If-
Oh, good.
We're just-
I think it's well written because it takes out some of the stuff that was in the complaint itself.
I don't want to gloss over that. It's important.
I mean, not glossy over, I agree, I agree with, it. I think the unprofessional nature of complaint 3, unfortunately, should have been removed because, what you did in your statement, because once you bring in the situation of professional, then we're in a different level now, aren't we? You cannot, in an executive session, talk about someone's professional character. So that would have been dinged anyway. It was more about a rude and discriminatory, perhaps. But I agree with those in the complaint number 3. That I am rude and I am discriminatory, but not unprofessional in acting as myself. So I like the tone of the apology. And I'm very sincere about it.
Any comments? No. Chris, was there anything that you wanted to add?
No, I think it was very appropriate.
So I will make a motion that we issue this public apology to the Ochoas this evening.
Awesome.
All in favor, Bryant, Bruce?
Yeah.
Chris,
Yes.
Walter?
Yes.
Cheryl, yes. Hope that you accept our sincerest apologies. Since we didn't go into executive session, I'll make a motion to adjourn.
We never wanted to.
I said since we didn't go into executive session.
Oh, I'm sorry, I didn't hear. Sorry.
So I'll make a motion to adjourn the meeting.
Second.
Okay, Brian,
Yes.
Bruce, Chris, are you in favor
Yes.
of adjourning the meeting?
Yes.
Walter,
Yes.
Cheryl, yes.
Thank you.
Okay, thanks, Kate.